Hey everybody, Mrs. Peterson here, and I wanted to talk to you about this week. We're working on copyright this week, and if you've been in my class before, I have changed it up a little bit. There's some stuff that's familiar and some stuff that's new. Today we'll be doing copyright part 1. The next time I see you, it'll be copyright part 2, and the next time I see you is copyright part 3. And each one of them has interactive things for you to do online, or if you're in my class, we'll do it in class. And then we will do something at the end to finish up copyright. So what I've pulled up for you already is the SWAY for copyright part 1, which is regulations and vocab. Laws and regulations vocab, sorry. So I'm going to go ahead and show you the assignment in Google Classroom. It says, watch the video from Mrs. Peterson, that's this right here. Take notes on the vocabulary words. So here are the vocabulary words right here, and you're probably going to want to write those down first before you watch this, and pause as you go and write down the definitions. Then when you're finished, you'll click on this, and it's an exit ticket, and it's going to take you to this screen right here. See how long it takes. It's taking just a little bit of time, but you'll see my name at the top, Mrs. Peterson, and some things that have to do with, oh, okay, so you're gonna, here are the information right here, and then you're gonna scroll down to Mrs. Peterson right down here, third from the bottom right there. You click on that, and it's gonna take you to this box right here. This is the one I was telling you about with my name and the cameras and stuff at the top. So you know it'll be me, and you're gonna be filling out this for me anytime you have class with me. That gives me a way to count you absent or here. If you don't fill it out on the day that you're supposed to have class with me, you will be counted absent. If you fill this out, you'll be counted present, okay? Email address, first and last name, grade, class period, class name, it's drop down, okay? And then how did you interact with me? Okay, so click all that apply, and then explain anything, and then the next screen gives, I can't go on to the next screen because I haven't filled it out, and it has a couple more questions, and you finish that up and send it to me, and that concludes how we're taking roll now, which is really great for you because then you don't have to be figuring out if I'm counting you here or absent, because it's going to go straight into our system, right? So here we go, back to the copyright. All right, so we're working on vocab. This is a little bit of a chunk of stuff that we're going to go through. All right, so vocabulary. The first word is copyright, and you've probably seen this symbol. Here is the definition: a form of protection grounded in the U.S. Constitution and granted by law for original works of authorship fixed in a tangible medium of expression. I'm going to go ahead and go, because if you're watching this video, you can pause, okay? So here's a video about copyright that we're going to watch.
In September 2015, a judge ruled that the song Happy Birthday does not fall under a valid copyright. Although many people are unaware, for decades the song could not be used commercially without incurring royalties to Warner Chappell Music Group. They claimed that they owned the rights and collected an estimated $2 million a year off of it. But how is something so simple and universal even considered to be owned by a single company? How exactly does copyright work? Well, copyright is protection for tangible expressions of an idea. It's intended to give the creator of something original the ability to use and make money from it without others being able to use it themselves. But copyright law isn't a blanket ban. There are a number of limitations that do allow for widespread use. First and foremost, it's important to note a distinction between copyright and trademark. You might see these frequently represented by the symbols C and TM. Although they generally protect the derivatives of an idea, also called intellectual property, each applies to different types of property. Copyright tends to cover literary and artistic work, for example, movies and books. Trademark is more often used to protect a company's brand and would include things like logos and names. Trademark is the reason you don't see thousands of knockoff McDonald's restaurants, while copyright is the reason you can't just print and sell the Lord of the Rings books or download pirated movies. But what you are and aren't allowed to do in regards to intellectual property is entirely based on which country you're in and how strict their copyright laws are. Now, most of the world adheres to the Berne Convention, which was the basis for most modern copyright law. Its greatest contribution was to establish the concept that the creator of a piece of work has automatic copyright from the moment of its creation in a fixed, tangible form. Still, there are small differences between countries in how that law is implemented and enforced.
That was called the Berne Convention. You might jot that down. B-U-R-N-E.
In US copyright law, there are specific limitations on how long an idea can be controlled by a single person. This is usually pegged to expire 50 to 100 years after the death of the creator, after which time it falls into public domain. When something is in public domain, anyone can use and reproduce it. There are also instances where a small portion of copyrighted works can be used without violating copyright. This is referred to as fair use, and is usually for educational purposes, parody, criticism, research, and so on. One of the biggest reasons for this is to prevent censorship by saying that any mention of an existing work would violate its copyright. Copyright law is complicated and dense, and it doesn't even apply in a number of countries which haven't signed any international copyright treaties. But in the rest of the world, the ability to control and profit off of your ideas is an important aspect of the economy and intellectual property. There's more to copyright law than meets the eye. The same goes for the First Amendment. To learn more about how complicated freedom of speech and religion are, check out this video. Most importantly, and perhaps the source of so much misunderstanding, is that the amendment begins with, "Congress shall make no law." Many people gloss over this part. They believe that the First Amendment personally guarantees them an inalienable right.
We're going to stop there. So this video is not meant for you to write down every single thing in it, because it's a preview of everything I'm going to talk about, all right? So hopefully you didn't stop that all the way through and write down all those definitions, because I have them written down as we go. So here's the fair use doctrine. It was mentioned in the video. A guideline that, here, I'll stop it up here. Guideline that determines how much of a copyrighted item, let me start that again. A guideline that determines how much of a copyrighted item can be legally used without permission. Okay, now this is something that we're going to go into a lot more next time, and it's a new type of way of looking at it. But there's 4 factors, all right, in fair use. And this is what you need to know, because everything that you do in my class has to do with fair use. So is the purpose of it to make money? Then it's less fair use. Is the purpose of it for critical, educational, and nonprofit? Then it's more fair for you to use it. Is the nature of the source unpublished or creative, or is it factual and published? So the green side, it's more fair to use. The red side, probably you shouldn't use it. Amount of sustainability. So how long is it going to last, or how much of the work did you use? So if you used a large amount of the work, it's probably less fair for you to use it. Or if you borrowed from what that whole work was about, it's probably less fair. But if you used a small amount, or just kind of a few topics from it, then it's better. And then the last one is it going to harm the market if you put it out? So the person who had it copyrighted, are you going to harm their market? Or it's not going to be any market harm. So if it's just for social studies class, it's not going to harm the market. All right. Now, here is something to look at when it comes to these 4 things. So how many of you have ever heard of the Lion King and Kimba the white lion? So just by looking here, you're seeing that there's a lot of things that the Lion King literally stole from the movie Kimba, which was made in the 60s. Even the position of the animals, even some of the characters themselves. So it's up for a copyright infringement, because they took so much of the core of it, right? So we'll go on. First sale doctrine, right? This is a short video about what is the first sale doctrine, but here it says it allows the purchaser to transfer lawfully made copy of the copyrighted work without permission once it's been obtained. So if I buy the CD to the newest Star Wars movie, and then I'm finished with it, and I sell that CD to my friend, it's okay because I don't have to ask permission for that because I'm selling the actual product. It's different if I'm selling a downloaded copy, all right? And here we go. We're going to watch this guy. Make it bigger.
So what is the first sale doctrine? Well, this applies to copyright law. So a copyright holder has the ability to prevent others from reproducing and commercializing their copyrighted work. Okay, that is, so as long as they have permission to do so, they have the exclusive right to sell and trade in it and commercialize it. But once they have sold an item that is subject to their intellectual property, their copyright, the purchaser of that item can then resell it. The original copyright holder cannot restrict, generally, the resale of a copyrighted work that's purchased. Okay, now there are some limits on this, particularly through contractual relationships, etc. But the copyright itself does not provide the right of the copyright holder to restrict that. So I purchase a book that is the content of which is subject to copyright. I can later sell that book to somebody else. Now, I can't write out in my own book or type out the book itself and resell that to somebody else, because that's not what I bought. In that situation, I'm copying somebody else's work, which is subject to copyright, and that's an infringement, and I'm commercializing it, so that's an issue. But if I simply resell the item that I purchased to somebody else, then that's completely fine, subject to the first sale doctrine.
Okay, so that's first sale doctrine, okay? And it's just about selling something that you already bought. It has to be a physical copy, you guys. I mean, yeah, that's what we're going to head off with. So, okay, intellectual property, right? Intellectual property is the intangible property that is a product of the imagination for copyrights, patents. So things that I've come up with from my head that can turn into those things is the intellectual property. I own it, right? I might not have a physical copy of it because it might be on my computer, but I own it. So it's my intellectual property. All right. So this next one is patents. So I don't know why I put the video before the words, the definition. Thank you. Monopoly granted by the U.S. Patent Office for a limited time for the creator of a new invention, right? And this does a great job of showing patents. If you've ever played that game Monopoly, your goal is to have everything and to get money from everything because you own it all. So now let's take that into patents. Here we go.
Hi, I'm Stan Muller. This is Crash Course Intellectual Property, and today we're talking about patent law. That's why I'm wearing these fancy patent leather shoes. They're a little too small, and I had a hard time putting them on. If only somebody would invent a new, useful, and non-obvious tool for forcing feet into too small shoes. Mark, can I take these off now? A patent is a grant by a government that allows an inventor to maintain a monopoly on the use and development of an invention for a limited time. Patents allow inventors to prevent or exclude other people or companies from manufacturing, selling, or using their patented inventions. Governments grant these exclusive rights in exchange for the clear and detailed public disclosure of inventions. So here's the deal. You invent something awesome, explain how you did it in patently obvious terms. We'll let you be the sole owner for a couple of decades or so, which should give you enough time to make some money off the thing. Ideally, you'll get rich for your inventive efforts before the term expires, or maybe you'll pour all that money into more research and develop new patents. The notion of giving talented inventors and innovators a limited monopoly in exchange for their instructing the rest of their less talented fellow citizens is not new. It's generally accepted that the first systematic patent law was developed in Venice, a hotbed of Renaissance industrial activity. The 1474 Venetian patent statute sums up the economic rationale of patent law pretty nicely. We have among us men of great genius, apt to invent and discover ingenious devices, and in view of the grandeur and virtue of our city, more such men come to us every day from diverse parts. Now, if provision were made for the works and devices discovered by such persons, so that others who may see them could not build them and take the inventor's honor away, More men would then apply their genius, would discover, and would build devices of great utility and benefit to our commonwealth. Wow, these Venetians really thought a lot of themselves. Grandeur and virtue of our city. This idea of granting exclusive rights to inventors to encourage discovery spread throughout Europe, into England, and then to the United States, where it was incorporated into the U.S. Constitution. In order for an innovation or invention to be patentable, the invention must satisfy 5 requirements.
We'll stop right there. That's only 2 minutes into it. We're not going to watch any more of that. Okay. So the thing is if you get a patent on it, then you're able to sell it for a certain amount of years, usually 2 years, and nobody else can sell it so that you can make money on it. Think of it that way. Okay, there's patent. Did I do the first? Okay, sorry about that, you guys. All right. A monopoly, I just talked about, is granted by the U.S. Patent Office for a limited time, right? Now we're going to talk about the difference between trademarks and copyright. All right, and this little video. There's only a few more videos, but they do a great job of explaining some of this. All right, here we go.
So you're a dreamer. Ideas come to you naturally, and you're wondering how to protect them. Well, first things first. You can't protect ideas themselves. You can only protect expressions of an idea. So, to receive copyright protection, your original idea would have to be in a fixed form, such as a book, photograph, or recorded song. The good news is that once you create an original work, you own the copyright. However, to better protect your work and prevent others from stealing it, you'll want to officially register it with the federal government. Trademarks, on the other hand, have more to do with business than creativity. The idea behind a trademark is to prevent confusion between the goods and services of one brand to those of another. Just by selling your products or services, you do have some rights. However, officially registering a business name, brand name, logo, or slogan with the federal government gives you additional rights, including nationwide protection of your mark. A registered trademark can also help you stop others from selling goods and services with similar trademarks. Patents are all about innovation. A utility patent protects the way something works, while a design patent protects the way something looks. In order to get a U.S. patent, you have to be the first one to apply for it. Being the first one to invent it doesn't count. But if you aren't quite ready, don't worry. Filing a provisional application saves your place in line for up to 1 year and gives you the right to label your invention patent pending. When you're ready to register your copyright or trademark or file a patent, that's where LegalZoom comes in. Simply fill out our online...
And the rest is an advertisement. But it tells you the difference between those 3. Copyright, trademark, that was the hardware store thing, and then patent, the way something works or the way something looks that you created, right? Let's go on. Wow, that's a lot of dark. What did I put there? Trademark. Wow, there we go. That was a lot of dark to say that. The trademark can have a little R on it, or it can have a TM in it, all right? Trademark, a word or symbol used to identify a product or service in the marketplace. If it has that trademark on it, it means it's registered with the government. So if your Nike swish is trademarked, then people can't use that. It's copyright protected, or the name of your company, or your logo, things like that. Okay, we'll keep going. So this is Captain Copyright. So I've dedicated my life to protecting the rights of artists, writers, musicians, photographers, filmmakers, and everyone in between. Captain Copyright. Okay, permission. This is a lot to do with our class as well, and you'll see as we go, right? Consent to use someone's work, usually by reprinting or reproducing it in somehow, right? A couple of years ago, we made a t-shirt for the yearbook, and we really liked this picture of a camera that an artist had drawn. So we sent them an email, and he took about a month and a half to get back to us, but he said we could use his picture on our yearbook, so on our yearbook shirt. But we asked permission. But Disney This is kind of a funny symbol here because it's the copyright symbol, but it has the Mickey ears and then the infinity sign. Because for a long time, Disney made it so that nobody could have copyright on their product, Mickey Mouse, for the longest time. And this is going to tell you a little bit about it, Mickey Mouse and copyright law. Okay, here we go.
One of the world's most recognizable characters, Mickey Mouse, is also one of the driving forces behind copyright law, specifically how long copyrights can last for. Almost all pop culture that came before Mickey, The Yellow Kid, Huckleberry Finn, Charlie Chaplin's movies, are in the public domain. But everything after, Goofy, Bugs Bunny, the Ninja Turtles, Luke Skywalker, as long as Mickey stays protected, they're protected as well, as long as they exercise their renewal options. Back when Mickey first appeared in 1928's Steamboat Willie, copyright gave creators rights to their work for 28 years, along with an option to renew for another 28. After that time passed, creative works would enter the public domain, free for anyone to use. Based on that law, the world's most famous mouse should have entered the public domain in 1984. Obviously, that never happened. In 1976, with 8 years left on the Mickey copyright and under significant pressure from Disney, Congress passed a new Copyright Act. Part of the act established that if a work was not yet in the public domain and still protected under the old law, its copyright protection now lasted 75 years instead of 56. Under that new law, the copyright on Mickey Mouse would now expire in 2003. However, in the mid-90s, Disney began to heavily lobby Congress to extend the law even more. Then CEO Michael Eisner was even spotted at the offices of various congressmen. He was very much interested in seeing the copyright bill. I think we need to do it. I agree with him. Then House Speaker Trent Lott would later say of Eisner in an interview with Congressional Quarterly. And in 1998, with only 5 years left on the rights to Mickey, Congress passed and President Clinton signed the Copyright Term Extension Act. The new act extended copyrights even more. If something was made in 1923 or after and still protected by copyright in 1998, it would not enter the public domain until 2019 or later. One law professor we spoke with, Christopher Sprigman at NYU, told us that, quote, traditionally the Walt Disney Company has been very good at convincing Congress to do what they want, end quote. As recently as 2008, brand experts estimated Mickey's value to the Walt Disney Company at $3 billion. With only 8 years left on Disney's Mickey rights, there's a good chance a new bill could appear in Congress in the next few years. After all, it's in the interest of anyone holding a copyright, Warner Brothers, Viacom, NBC Universal, to never let the term on Disney's mouse expire. As goes Mickey, so goes everything else. The irony in all this? A multitude of Disney's biggest hits, Cinderella, Pinocchio, Aladdin, and many others were all adapted from the public domain.
Not funny. All right, so I thought that was a great description of, oh, hold on, we just jumped into
As we overcome the pandemic.
another video there. We don't need that. Okay, we're almost to the end of our definitions for today. I know this was kind of long, but we're getting through it. This word phonorecords is just something that you have to identify. It is digital phonorecords are a relatively new technology that allows musical works to be played, recorded, and stored in digital format instead for use on other devices. This is what used to be when we recorded stuff. In fact, this is a music box right here from the 1800s. This is a phonograph. It's not even a record player. You would wind it up right here. This is a reel-to-reel tape recorder. This is a record player with vinyls. And then in the front here, let's see if I can show it. No, it's not letting me. They also have a tape right down here. So we have 8-track tapes and cassette tapes, and now everything we do now is pretty much MP3. So a phonorecord is an MP3. All right. Those are those pictures. I copied everything straight off the internet. Plagiarism. You've heard this probably in English class, but it counts in pictures and videos too. To steal or pass off ideas or words of another one's own to use in another's production without crediting them. All right. Public domain, we watched a little bit about that, Mickey Mouse. The works which copyright protection has expired and it belongs to the public. It's the public domain. You can do with it what you want. And is created, or if it's something that is created by employees of the US government. If it's a document, a tax document that the US government put together, that's public domain too. And that is the end of our presentation. So make sure when you finish, you go here, you will have finished watching the video, which will be here, and then you go to this learner exit ticket. We'll do something else the next time I see you that has to do with copyright. I love you, I miss you already. Go out and change your world for the better, even at home. Bye-bye.